Recording has started. So good afternoon, everybody. My name is Jo Thomas. I'm the Innovation and Intellectual Property Lead at MFT. I work in the innovation team, and I've been working in IP now for over 24 years. We've turned the chat off and Q&A off. So if you really do need something, you're just going to have to turn your mic on and speak. And Claire Howard, who's on the call today, will be like the main voice of the participants if there are any issues. But there will be time at the end for questions. So if you've got anything, please hold on to it or make a note of it, and I'll be really happy to answer them at the end. So I'm going to start by telling you what IP is, why you need to understand it and how you can protect it. I'm going to talk a bit about who owns the IP that you create, what you need to think about when you're creating IP belonging with others, or if you want to use IP belonging to others. I'm going to do a little bit on IP and grant funding, and I'm also going to cover what to consider when publishing papers. I've got a few real anonymised NHS examples to highlight some things as we go through. And the presentation is in 6 sections. So if you're getting bored, you can look at the numbers and see them count down, and the sections tend to get smaller towards the end as well. So I'm going to start with a poll. So just let me launch the first poll. It takes a minute for it to just come up onto my screen. I had people up before. So my first question to you, so this should be popping up on your screen now, is which of the following do you create? And there is a scroll because there's one at the bottom: documents and reports, PowerPoint presentations, software code and apps, recordings or videos, website content, data and promotional materials. You can tick all that apply and then click on submit. And once you have done that, I should be able to see the responses. Okay, so it's looking like documents and PowerPoint presentations are the most common, which is what we'd expect. A little bit of software, that's interesting, and a bit in all the other areas as well. That's brilliant. I'm going to close that poll. And if you want to get rid of the poll in the middle of the screen, I think you click on done, and that should disappear for you. Okay, you'll understand why I've asked you that in a minute. So I'm going to start with what is IP, why is it important, and how is it protected? So intellectual property is something that you create using your mind. And like other types of property, it has an owner. That could be a person, it could be an organisation. It can be bought or sold, or it can be shared freely, just like any other type of property. If you can sell your house, you can rent out your whole house, you can rent out a room, you can let your friends stay in a room for free. It's the same thing. And different types of IP are protected by different rights. So as you might have gathered from my first question, IP includes lots of things: documents, reports, papers, surveys, software and apps, websites, lab tests, devices, knowledge, data, films, diagrams, photos, presentations, sound recordings. Lots and lots of stuff falls under the banner of IP. So a lot of researchers will say to me, oh no, I don't generate any IP. Well, you're always generating IP when you're doing research or indeed any other kind of innovation. So why do you need to know about it? Well, the first reason is that if you understand it, it gives you control over how it can be used by others. The second point is you must sort out any IP issues before you can share the IP that you create. Number 3 is that sometimes you want to use IP that other people have created, so you need to understand what you can and cannot do. And if you don't understand that, then point 4 is you can actually get into trouble if you use IP incorrectly. So don't want to scare you, but I just want to make you realise that actually you do need to be thinking about it. So this is a busy slide, but it's just a bit of a summary of everything in one place. So I've given you lots of examples of IP, and so different types can be protected in different ways. So written and artistic work tends to be protected by copyright, so documents, code, presentations, films, photos. Now, I'm going to tell you a bit more about that in a minute, but effectively it's free. There's no application for that. The one that everyone tends to think about as IP are inventions. So those have to be new, something that's new, quite novel, inventive. It has to be something that can be made and used. You know, it can't be just something theoretical or some kind of method. And so things like equipment, medical devices, drugs and tests that fit under the criteria could potentially get patent protection. Now, there is an application process, it costs money, it takes time, and they're pretty rare in the NHS. You know, I don't see that many of them, so I'm not going to go into those today. The next type of IP is your brand, like the word or the name of your company or your organization or your product. But it also includes like logos, sound. So I don't know if you remember the Intel thing. There used to be the do 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 do. That's a trademark. Colours, EasyJet orange, that sort of thing. Anything really, some kind of mark that other people recognise as that's come from that organisation can be protected as a trademark. There's an application process for that, and I'm going to talk to you a bit more about that shortly. Then we have designs. So those would be things like the sort of the configuration of something or the physical shape or some surface decoration like a pattern or something like that. That can be protected by design right. There is a registered design that you can apply for. There's also some unregistered design rights. But again, they're not that common in the NHS, so I'm going to skip those today. And then the final one is sort of IP, but we tend to group it as the same, which is your knowledge, your know-how. It could be an idea, it could be a method, it could be information gained from being a clinician over many years. It could be a trade secret like the Coca-Cola recipe or the Kentucky Fried Chicken recipe, that sort of thing. And you protect that basically by deciding who you tell. If you don't tell anyone about it, it remains secret. Sometimes you do need to tell people because you need advice or you want to work with others. And then we recommend that you use a confidential disclosure agreement for that. And that is something that we can help you with if that's appropriate. And like I say, each type of protection has sort of different types of criteria. So if you want more detail, come to me. So I said I'd talk about copyright. So this is the most common right that we use in the NHS as a form of protection. And as I explained before, original written or artistic work is covered. So this PowerPoint presentation has got copyright protection. And that right stops other people from copying or reproducing it, or rather it allows you to stop them. If they used it, you could go to them and say, this is my copyright, please stop using it, or, you know, we might take you to court effectively. It is an automatic right, so it exists as soon as the work has been created. There, you don't actually have to do anything. Some people think you need to register it. Nothing like that is required. But a copyright statement is actually helpful because it tells other people who don't understand copyright that the right exists. So you'll have all seen the C in the little circle, which actually, if you do like open brackets C and close brackets, it automatically changes it to that, which is annoying when you don't want that to happen. That with a copyright statement, which I will show you in a minute, and will give you some idea what to say. So it's free. In terms of how long the protection lasts, it's actually a long time. Now, I've said it usually lasts for 70 years after the death of the author or the last author. So this PowerPoint presentation, even if I died tomorrow, would still last for 70 years with copyright protection, which is quite a long time. I say usually because copyright protects lots of different things, and so there are some nuances, sound recordings, broadcasting, etc., that have some slightly different things. It's often 50 years, but for most of our written stuff, it will be 70 years. And as I said before, it can be shared like other property. It can be sold, it can be licensed for free or for a fee. One thing you do need to be aware of is that it protects the expression of the idea rather than the idea itself. So This presentation is on IP and it's geared towards the NHS. So if somebody copied my slides, then we might be able to say, we know you've breached our copyright. But it doesn't stop other people coming up with other presentations about IP in the NHS. So that's what we mean by that. And you can get similar protection in other countries. So in terms of the statement to use, it can actually be quite flexible. Effectively, what you're doing by adding the statement is telling people who created it, so who owns the work, when it was created, and what other people are or aren't allowed to do with it. So I've got a couple of examples here. The first one is copyright to the NCA 2025, all rights reserved, not to be reproduced in whole or in part without the permission of the copyright owner. That's a pretty standard thing. You know, you've basically got to come to us before you do anything. I've got another one below, which has got the statement, this material can be reproduced by NHS trusts on the condition that it is not modified and the NCA is credited as the creator of the material. So you can put other things in there. You can have much longer statements. You could put in contact details and things like that. So there isn't a sort of a set thing really, other than really just having the name and the year. And actually the C in a circle isn't required. Otherwise, sometimes people just write copyright. So moving on to trademarks then. So I was looking to see what registered trademarks the NCA had, and I came across this one, the 48 Bakehouse. I can see 4 people. Have any of you seen this trademark before? Okay, so it's a mix of responses. So I thought I'd use that as an example as I went through trademarks. So I've already explained that it can protect distinctive signs that can be used to distinguish your product or service from those of a competitor. And remember that brands are quite powerful because you do associate things with a brand. So John Lewis, you might think of as, oh, well, it's a quality product, it's good customer service. You might sort of think of as a cheap clothing shop, as sort of cheap fast fashion, you know, long queues, but you know, it's a very affordable price. So we do all have associations with these marks. And you can have an unregistered trademark, which is just automatic, and you put the capital T and M. You'll have seen that sometimes next to a name or a logo or something. But it's fairly weak protection, and so we would recommend you went with a registered trademark. And you might think, well, what is that? How is that relevant to us? I think mainly training. I've seen it a lot in training programs where you've got a name of something that's distinctive, and then it just means that every time people hear it, they've got that protection, and it means other people can't use that name for that course because you've got the trademark protection. So it stops other people from using your name or logo. And also, if you get it registered, then if anyone tries to register something similar to it, the Intellectual Property Office is likely to notify you and ask you to sort of have a comeback, you know, say, is this an issue for you or not? The process is that you apply to, like I say, the Intellectual Property Office, and you apply to get certain classes covered. Because you can have the same sort of mark in a very different area. So I use the examples of Penguin Biscuits and Penguin Books. You know, the name is the same. You don't get those confused, and you don't get Polo Cars and Polo Mints muddled up either. So using the NCA example of the 48 Bakehouse, it's got registration in 5 classes. Number 30 covers bread and pastries, 35 is retail services, 36 is fundraising, 39 is food delivery service, and 43 is services providing food and drink. So you get a fairly good idea of what a service they're going to provide. So you apply, it's examined, they look for similar marks. If there aren't any and nobody contests it, then you get it granted. You can use it might not be that easy to see, but the capital R in a circle. You can then add that to your name or your logo or whatever, and that really is pretty good protection. I think it's really good value for money. It costs 170 for the first class and £50 for each extra class, which in the scheme of IP protection, if you think about patents that are thousands of pounds, it's really good value because it actually covers you for 10 years and then you can renew that indefinitely every 10 years for paying similar fees, really. Like other IP, it can be sold or licensed. And there are some criteria that you have to comply with to be able to get a trademark. So it can't be descriptive. So it couldn't have just been hot food or hot tasty food. It can't be generic like the restaurant. It can't be offensive, and it can't be similar to other marks for obvious reasons. You can get trademarks in other countries as well. The most relevant one perhaps to us might be the EU, and there's one application process that would then cover all the countries. So I'm a big fan of trademarks. I thought I would also mention to you that you can get layers of IP in things. I think people sometimes don't realise that. So again, I was looking for NCA stuff and I came across this NCA family video. And so there will have been a script for that. There will have been some music. There would have been some actual recordings of people, and there would also have been the NHS lozenge under the NCA's logo. Well, all of these, so script and the soundtrack and the recordings, all have their own copyright. So they've got their individual level copyright, and then there's sort of copyright of the film as a whole. And then obviously the NHS lozenge is a very valuable trademark. Okay, I've got another poll for you, so I'm just going to launch that now. So that should be appearing on your screen. So can you tell me, do you collaborate with others, commission work from others, or none of those? So if you can just vote. And just waiting for a few more responses to come in. Okay, this is as I expected. More people collaborate than commission, but there is a bit of commissioning there. So I'm now going to talk about who owns the IP that you create or use. So there's three things really to tell you about IP. It is complicated. The first thing is that your employer normally owns the IP that you create during the course of your employment. There are some exceptions, which is why I say normal. And this is really even if it's been done in your own time. So if I did this PowerPoint presentation all in the evenings and on my home computer, that doesn't necessarily matter. It's very much related to my job, so my employer owns it. The second thing is that if you commission work, it doesn't mean you own it. Even though you've paid for something, it doesn't necessarily mean you own it. And the third thing is that if you're collaborating or working with others, then you can get some joint IP ownership. So I'm now going to go through each of these in a bit more detail. So the first thing is about your employer owning the IP. So when we say employer, it means the organisation on your wage slip. And I say that because we have some really complicated employment relationships in the NHS. So it could be common for a consultant, say, to be working in your hospital but have a university contract and own an honorary contract with the trust. So the university would be their employer. I used to work with a Macmillan nurse who had funding from Macmillan but was employed by a trust. And so there, even though Macmillan had paid for their time, it was the trust who was their employer. Then if you think about secondments, you stay with your original employer, but you then go and spend some time somewhere else. Okay, sometimes these secondments are internal, but sometimes they're not. And you might be working on a project for your visiting organisation, so to speak. There could be an issue there if you're doing a project for them, but you've still got employment elsewhere. And then there's trainees, so medical and dental trainees. So you may or may not be aware, but a lot of them go on rotation and they have what's called a lead employer. And so even when they move around different trusts to get their experience in different areas, their employer stays the same. And I believe Mersey and West Lancashire Teaching Hospitals is the main one for the Northwest, or the only one for the Northwest now. They used to be St Helens and Knowsley. And to give you a sort of a real example, we had a surgical trainee who was on rotation, so had a lead employer and then a host employer where they were working. And they created some software for their host. But because the host wasn't the employer, they actually needed to go to the employing organisation to ask if they could own the IP before they could then share it with other people. So that's why employment is key. And whenever you come to me, I'll always be asking you who's everyone's employer, because that really informs our decisions. So now let's think about when you're getting other people to do stuff, when you're paying them to do things. So commonly this could be you're getting a website created or some software or an app written. It might be that you've commissioned somebody to create you some training materials or do some videos. Now, that work could be done by somebody that's very obviously external. So they're like a creative or digital marketing or something company like that, where it's very clear that they're sort of separate from the trust. But you do sometimes get people on external contractors working in an organisation. I've certainly seen it in IT or digital services, where from a department perspective, the person in the next desk, you can kind of think of them as equivalent to you, but actually they're sort of a contractor. And so again, if they're not employed by your organisation and they create stuff for you, the trust isn't necessarily going to own it. So we say, if you've got something ongoing, check the contract, see what it says. Sometimes the creative company or whatever will say, well, and once you've paid us, you get ownership. Seems fair enough, but that isn't always the case. And if it doesn't say that, then you only actually have permission, a license to use it for the purpose that you've told them about. So the message is check your contracts. And the example I've got here was actually does relate to IT. This was a few years ago now, and it was an NHS organisation that had built quite a hefty information system that had a lot of really useful information for lots of organisations. But they used mainly external contractors like freelancers. And when they were getting interest from other NHS organisations and were looking about selling it on, they found they didn't own all the intellectual property. And these external contractors were pretty savvy, and they actually wanted quite a lot of upfront money to transfer ownership of the IP that they owned to the NHS organisation. And it was too much for the organisation to be able to fund. And so it didn't go anywhere. And they created quite a massive resource, and they couldn't share it with other people. So that's why this can be so important. Okay, so working with other organisations more generally. So by this, I sort of mean when you're collaborating with others, so universities or charities or companies or other NHS organisations. And some of you will already know that we're not one NHS. We're all separate trusts. GP practices are separate, and so we are all individual organisations. And so if you work together on something and there's no kind of agreement in place, then, and you've two of you, say a university and a trust employee, have created something jointly, then the IP could be jointly owned. Now, a lot of people think that's quite nice because, it's equal, but joint IP ownership can be really complicated and messy. We don't recommend it, and lots of other people don't recommend it either. It's much better for one organisation to lead and take ownership of it. The others can still be acknowledged, they can be given permission to use it, and they can get a share of any money if the thing's going to be sold. So we always recommend you putting an agreement in place before you start to cover the work. Now, if you're doing normal research, going through the normal research processes, the research office will provide you with a collaboration agreement that will cover that off. But if you have done something and there wasn't funding, so it didn't go through those channels, it isn't too late to sort it out. We've sorted it out retrospectively many times. So again, just get some advice. Couple more examples. There There was a case where a trust developed a patient guide that was going to be used in a university research project. And because the university was leading on the project, and the collaboration agreement said that the university owned the IP. And what this meant was that because the patient guide had been created specifically for the project, the university owned it, which meant the trust couldn't actually use it with its own patients outside of the research project without getting the university's permission. So that's one thing. I mean, often with some of the agreements, we do have a license back to use it for internal purposes, but this one was tricky. It was an old case. And then there was another case we had where two NHS organisations had created something jointly. They had joint ownership. One wanted to sell it and one wanted to share it for free. And because they couldn't agree, they couldn't do anything with it because they didn't have the permission of the other party. And so that also didn't go anywhere. There's a moral here, isn't there? And my final example is one that involved a nurse. So she was developing some training. And she planned to collaborate with a company that provided surgical supplies, and they'd agreed to give her access to some of their materials as part of the research project. So she applied for a grant, got the money. And when funders, I'm going to talk a bit more about funding in a minute, but the funders often ask IP questions. And as we started to answer those, the first thing we found out was that the company only wanted their existing customers to access their materials, and those company customers weren't the same as the research sites that the nurse had got lined up. So that caused an issue, and there were a few other issues that conflicted with the funders' terms. There were huge project delays. The last time I heard, they were actually unable to reach agreement. It was so complicated and so difficult that they weren't able to sort it. And it's totally avoidable by having a discussion about IP at the start and discussing plans fully. And I was talking to Claire about this yesterday, that talking about IP actually brings other things to light, and talking about agreements. Really, you just want some detail about what you're going to do, who's going to do what, how's it going to work. This is what we want to do. That's what we want to do. This is what we expect to get out of it. This is what we expect. It can actually make a project much more effective just by having those discussions early on. Moving on then to section 3, which is about using IP created by others. So I've got another poll for you. So I'll just launch that now. And this is a simple question. So you've seen an image on a website, and so it's in the public domain. Do you think you can use it? Please answer true or false and submit your responses. Okay, I'm just looking at responses coming in now. So most people think it's false. I'm going to answer that in a minute. So using other people's materials. So this is also really common. If you're doing research or you're doing some other kind of innovation and you're looking to evaluate something, you might want to use outcome measures that somebody else has developed, or some kind of assessment tool. You might want to use images, guidance documents, questionnaires, diagrams, presentations, films. These are all things that might have been created by other people. So if that's the case, the first thing you need to do is to find out who owns the copyright. And if that's not clear, if it's got an author on it, then contact them. Then you need to check if you're eligible for a free license. So some software is released as open source, which means that if you comply with their terms, that you can use it for free without paying a fee. Sometimes some of the outcome measures and things, if you're doing non-commercial research, you can use them for free. But do check the terms. And if it's not clear that you can use it for free and without permission, then you do need to seek that permission. Otherwise, you could be sued for copyright infringement. Now, in the process of looking at that, you will find out if you need to pay a license fee. And if you do all this before a project starts, when you're planning it, then you can cost that fee into your grant funding application. So it's never too early to actually be thinking about stuff. And even if you've used things before, just because you've used them in other projects doesn't necessarily mean you can use it for that project. It might have been you worked on a project with a university, say, and they had a license, whereas now you want to use it from the trust and you don't have a license. So always best to check. And in terms of the question I asked before, just because an image is on the internet, it doesn't mean you can just use it freely. It'll have copyright, or it may well have copyright protection. That's an automatic right. So you still really need to check if you need permission before you use it. So some examples here. So we had a phone call a few years ago now from somebody who had taken an image from the internet and used it on a website. And then they got a threatening letter from the images company that they'd got the image from. I think the company had some kind of software that could actually sort of look on the website and actually see who was using its images. And the company wanted to charge them several £100 to use that image, which they effectively had to pay because they were using it. My second example is as work given advice for somebody who was creating an online information system. This is different from the one I'd mentioned before. And they wanted to share lots of information. So it was intended to be used quite widely. And they had lots of photos and things on there, and they had no idea where the photos came from, where the images came from. So because they didn't know where they came from, we couldn't see what the license terms were, or if there weren't any. So what we advised them to do was to replace all the photos with images that they owned or had the right to use. And then there was one figure that was really important that they wanted to put in the materials. So we suggested that they got permission from the it was either an author or it was in a textbook or something, you know. So we said we'll get permission from them to use it for the whole purpose, not just you using it in this information system, but for you then sharing the information system with other organisations. So you can often sort things out. And then my final example relates to Sage and Time communication skills training, which I'm always mentioning because it is something I'm involved in. In that one, MFT owns copyright in all the training materials, the videos, the PowerPoint presentations, the website, and there's a trademark as well. And because we have ownership and control and we've sorted that out, we can license it to NHS organisations and hospices and others. We can charge them a fee. And then when we work with journals, we protect bits of the IP. And I'm going to come back to that when I talk about publications. Okay, number 4 then, funding. So when you're planning projects and dealing with funders. So this is a busy slide. I'm not going to read it all out. I don't expect you to read it all now. This is really to illustrate that you need to be thinking about IP at all stages of a project. So I've highlighted some of the key things to think about, but they're all relevant questions. So when you're planning a project, you need to start thinking about, well, who's going to own the IP that's created? Remember before I said it's better if one party owns it, but you don't just agree between you. You also need to think about, well, what are the funding terms? Will the organisations agree to that? And then also think about existing IP that you might be using either for the project itself and or at the end. So let's say you had something that a university had created and you were going to build on it or create a version 2 or for another clinical area. There'll still be some IP that will be the original IP, the background IP as we call it, that you would still need permission to use even if you'd added some other bits to it in your own project. When you're actually applying for the funding, please look at the guide the funders often issue, because that can give you some information on what they're expecting, which can help when you're talking to collaborators, because some collaborators will understand funders' terms more than others, especially if they're companies or charities, they might not be as aware. And then when you get the funding awarded, a lot of times now there'll be IP questions from the funders, and then we'll be putting terms in a collaboration agreement or some other kind of agreement to make sure that it fits what the funder wants and what we think is appropriate. When the project is ongoing, don't forget about IP. Sometimes if a project is quite complicated, if it's a big program of work and a lot's being created, sometimes we say create an IP log, who's done what and when, and that can be a bit helpful to keep track, especially if it's a project over several years. And, do have at the back of your mind, if we're going to share this IP partway through a project, does it need any protection? Should we add a copyright statement? Should we think about trademarking the name of this thing that we hope is going to be brilliant and go around the world? You don't have to wait to the end of a project, but obviously do think about it as well when the project comes to an end. Think about it in terms of publication, which I'll mention in a minute. And then also do be thinking about, well, we've done this project, we've hopefully got these great results. How do we get it out there to improve care or services or whatever you're intending to do with it? And then even after the project is ended and it's a bit further down the line, you might still need to monitor and manage the project, the IP. And also you might have other people wanting to use it, or you might want to use it in follow-on funding, in which case it would be background IP for that new project. So when you get the presentation, you can look at this slide in detail, but I just wanted to give you a bit of an overview. So in terms of the funders, many funders, so National Institute for Health Research, British Heart Foundation, Cancer Research UK, all have terms about IP. They want reassurance that you can use the background IP, the IP belonging to others. They want to be clear who's going to own the IP generated from research, which we tend to call foreground IP. They will have an expectation that you're going to manage it properly, that you're going to protect it. And also, if it's something that you can't just share freely at the end, if it's something that you need to commercialize, it needs to be a product, so you need to sell it, then they sometimes want a share of the money and also to perhaps consent to that commercialization happening. They also sometimes have the right to take control of it. If you don't do something with it and it's potentially very beneficial to a lot of the NHS, then some of them have the right to take that over so that they can then take it forward and use it for maximum benefit, really. So if you've got any projects ongoing, you could have a look at the IP terms in your contract if you wanted to just see what they say. But always you can get advice from us on any stage, including whether you should share something freely or commercialize it at the end. Number 5 is publishing papers. So if you get to the end of your project, you submit a paper and it's accepted. The journal sometimes wants to own the copyright. And if that's the case, then you'll have to sign something saying that you're going to assign, or that's transfer ownership of that to the journal. That means that the NCA no longer owns that, which means that if you wanted to reuse something, you would technically need their permission to do that. So I've used the Sage in Time example here because this box is in lots of our materials. It's on our website, it's in our training materials, it's in our delegate packs. We need to reuse it. So what we did is we assigned most of the intellectual property and then licensed certain boxes and figures that we wanted to reuse. The journals are, in general, familiar with this process, and it means that there's a copyright statement at the bottom. It's the name of the old trust, so that's why it doesn't say MFT. Sometimes you see reproduced with kind permission of, again, it's saying that somebody else owns the copyright in that thing. And we can advise on agreements with publishers if that's ever an issue for you. So I said I had 6 sections. Number 6 is a summary. Before I do that, I want to do my last poll, which I'm going to launch. Now, it's a word cloud. I don't expect the cloud to actually look great, but I just want you to type in a few words, one thing that you've learnt from today's session. It will be interesting to know, and also it's more likely to stick if you do it. So if you can just type in your response now and then press submit. And we'll just see what people say. A few other people still typing, I think. Okay, so I mean, it's basically just keep thinking about IP to protect your work and plan in advance. Thank you. So I'm going to close that poll and we'll summarise. So the key messages are: be aware of the IP that you're creating and or using, and also that in general an employer will own something unless there's an agreement to the contrary. Number two is when you're creating IP with others, and that could be whether you're paying them to do some work or you're collaborating with them more generally. It's best to put a contract in place to cover IP. Number three is to seek permission before using IP belonging to others and be aware that sometimes you have to pay for that. And number four is if you create something valuable, consider protecting it and seek advice on managing it. I mean, basically just get advice. You know, we don't expect you to be able to necessarily do much. All I'm wanting is a red flag to think, oh, IP, get some advice, not to necessarily know exactly what to do and never need our advice going forward. I will take questions in a minute, but so I don't forget, I'm putting this on the screen now. If you've got a smartphone, you can scan the QR code, or I think you can actually, I think the link below the QR code should actually work. So if you can either get that up, I don't expect you to do that feedback until after we've finished, but if you can get it up either on your phone or on your computer so that you can do it afterwards. And then I'll be happy to take some questions. So I'm going to stop sharing and see if anybody has anything they want to ask me. You're going to have to put your hands up, I think, so that we can see. Claire.
Yeah, thanks so much for that. That was so useful, and even at all the conversations that I've had with you, I've still learned more things today. One of the questions that sort of came to me while you were talking was around presentations. So, you know, quite often as researchers, we're asked to do presentations and we're asked to send them in advance, which then means that they sort of have that presentation. And am I right in assuming, I mean, quite often I say to people, I can't send my presentation in advance because it's got unpublished work on it. But sometimes they just insist that they have it beforehand. And am I right in thinking that we could potentially come up with some sort of agreement that says that, yes, you can have it in advance, but you do not have permission to share it or use it, or whether we should have some sort of written agreement for that?
It's a really good question. So in general, they want it in advance, I think, for technical reasons, so that they know it's uploaded, because people are normally rubbish, or some people are rubbish. Yeah. And you're right to be nervous. So I think there's a few things there. The first thing is, it is okay to put it in an email and be very clear that you're sending this presentation in advance. However, it is just for the purpose of uploading onto the system for, you know, during the session. You don't want it to be disseminated. You could send them, if they want it afterwards, you could send them like your version. So I tend to send it as a print to PDF afterwards, which also then doesn't have your notes, which often are the bits you don't want other people to say. And you could then also take out some stuff, and you could put like slide taken out because it's, you know, it's pre-publication or whatever. So I think probably getting them to sign something might be overkill, but you could get clarity first, and you can explain why you're nervous. But you can say, if you can, you know, if it is just literally to upload it onto the AV system, then here you go. But I will send it at the end, or here's the version that you can share with delegates if you're happy with that. I would also add a copyright statement, perhaps at the start, because obviously everyone sees the start, not everyone goes to the end. My last slide, which you didn't see, had questions on, did have a copyright statement on. So if you are bothered, and you could add more on that as well, you know, for delegates attending blah blah conference only, not to be shared with others without my permission. You know, you can, I mean, it doesn't stop people doing it, and it would be a case of you finding out, but there are ways you can do it. But I think probably just via email would be sufficient to control it.
Yeah, thank you. Thank you.
Any other questions, even what you might think of as a silly question? Go on, Claire. I
Sorry, I
always
had
like to
got the
count to
question.
10.
I was sort of waiting to see if anyone else had a question first before I before I took over the questions. Yeah, I mean, and again, it's a similar thing really, but it's to do with we always make a little logo when we start a new project because everybody loves a logo. We love an acronym and a logo, and quite often we just sort of we cobble something together that looks a bit like what the project should be. And again, that's something that we tend to not really think about copywriting or in any sort of formal way. And I just wondered what your specific thoughts were on that. I mean, I suppose in reality, what we could be doing is even copying a logo that we don't have permission to copy as well is the issue. But as early career researchers, it's something that we tend to do. We tend to sort of make up a logo.
Yeah, really good question. And that brings out quite a few things. Oh, I've just got thunder here now. If I crash out, that's because we've got a power cut. So things to think about with a logo. The first thing is, so you're right to be worrying about copying. And so whenever you create something, do have a look and see, if there is anything similar. And often the name as well. Often you can Google that, and sometimes there are common names. I've got an example, but I don't want to expose them. There's one thing I'm advising on, which is to do with autism, and the words that they've come up with is actually like there's a lot of things with that word relating to autism when you do internet searching. But the name means a lot to them. So they're going to have a logo. They did have a logo that often it's really common, it's somebody's son or daughter or niece has created. And so that's an issue in terms of IP ownership. So we get them to assign stuff. We had a case recently where a student created something. They ran a competition at college. So there's an issue over ownership sometimes, depending on who creates it. So we think about that. Like say, do some internet searching, both for the logo and the name, see if there's anything similar that comes up. In terms of protection, it wouldn't be copyright, it would be trademark. And also you can't copyright like a word or just a very short phrase. Normally you would have to, if it was a slogan, you would really have to register that as a trademark as well. And so it's a judgment call as to how far you get down the line. I think that the more widely something is used, the more helpful it is to have that protection, because obviously you're doing research, creating some new training or some new treatment or whatever that has a name associated with it, that if is going to be helpful to patients, will be used really widely. If it's a distinctive name, and I'm always very keen on, unusual names, something made up is really helpful because people don't get it confused with other things, which again is a good thing in terms of your branding and recognition. I would say that early on, try and get like a look and feel. So somebody, one team that I'm advising, they're doing some training and they've got a few materials. And like they did images from different places and things. And I said, well, just, get your images in order, get your sort of your branding sorted. What are your colours? They were using lots of colours at the start. They started to narrow down the colours. So it actually made it look more professional. And it also then meant that it perhaps mirrored their logo. Perhaps there was blue and red in the logo. So I think it's worth considering. And if you were perhaps say you'd done one project and you'd done like a proof of concept and it was working quite well, and then you were going to do a bigger project, it was going to go around a few sites, it might be worth thinking about registering a trademark at that point in time for, it might be under £200, but if it goes anywhere, you've got that protection and you can stop people from using it. One other thing to say is that if I use the Sage and Thyme example, obviously it's a word, Sage and Thyme, it's a mnemonic, but also there's a logo with some leaves. Those are two separate trademarks because they don't look similar. So whilst they've both got Sage and Thyme in them, they don't look similar in any way. You know, one's sort of just a particular font and another one is a very stylized thing. And so sometimes you have to register more than one. So sometimes, again, it might be a money and you think, well, what's more important? It might be the logo or it might be the name. So I kind of went around the houses with that, but that's because there's actually quite a lot to think about. But I think the main thing is to get a good name for something, Google it and see if anybody else is using a similar name. And if there could be cause for confusion in the future, change your name early on because it gets harder to change it further down the line.
Yeah, thanks for that. I've literally just Googled my my own research study to see if there's another one of the same name. And there is. But it's a knee therapy rather than a vision thing, so I don't think it's going to get mixed up. So I'm happy with that.
Fine, but you might decide that you end up with like a strap line, like for eyes, or do you know, or an eye logo or something like that that makes it more distinctive. Helen.
Thank you.
Slightly related to that. So with using images, so we all sort of pull images off the internet, don't we? Copy, like I do like a weekly message to our team and I'll put a funny image or something in it, or we'll put them in PowerPoints. But where is the line where you need to actually be serious and start to think about that? Because you wouldn't do it for every little sort of casual instance like that, would you?
It's a difficult one. I asked the question of our solicitor a few years ago when I was making I think it was a Power Rangers birthday cake, and I was saying, like, hypothetically, if somebody was making it, and, you know, he said, well, technically you're breaching their, you know, probably their trademark actually rather than copyright. But I think if it's internal to a small group of people, then the likelihood, I guess, of you getting found out is pretty small. However, you don't necessarily know where things are going to go at the start, and something that starts out small might spread. And you never know, you know, things can easily get forwarded. I'm a big fan of Pixabay. I don't have any shares or anything else in it. It's PAX, Pix, and then ABAY. And they have some images that you can pay for, which are normally pretty clear. And there are lots of images that are free. You can use them for commercial purposes. You don't have to you know, acknowledge the creator. It does tell you who's created them. You can say thank you and you can acknowledge them, but you don't have to. And to be honest, I get my pictures from there. And it's a massive source. Cartoony things, photo thing, you know, you can filter by color. So if you've, you know, so I tend to use that for most things now. Sometimes I just take a quick photo of something on my desk because I know, you know, like depending on what it is, you know, I'm a little bit paranoid about it because I never know. And, you know, like say I've done this presentation now, sometimes I look back, I've been in this job a long time and then I think, oh, where did I get that from? And I know that I've been good and so I can just reuse it and I don't have to worry. But if I didn't know that, then I'd be thinking, oh, you know, is that an image from somewhere else that might get me into trouble? So I think there are other image places available, but the Pixabay one is just so easy. It's got such a lot of resource that is really helpful. A good question, Helen. Right, we're coming up to time. We've got 4 minutes. There's time for one more question, if anyone can squeeze one out. Or a general comment, or anonymous asking for a friend. I've got a project that.
That was just so useful, Jo. Thank you so much. And the discussions that I've had with you over the last couple of weeks have been so important for getting my contracts right for my fellowship. And it actually really surprises me that I'm on my second NIHR fellowship and nobody's ever really thought about training in IP or and I've got to the postdoc stage without really thinking that it was relevant for me, thinking, well, IP is about developing, you know, some new tool, like you say. I never really thought about copyright for pictures and, you know, PowerPoints and publications. But Dominic's got a question, so I'll stop talking.
Hi.
It's just a quick one actually. Where does copyright stand from an AI curation perspective? Say you curate an image, you ask AI to create, like, I don't know, anything. It can do that now, right? What happens to copyright there?
It's a really good question. So there's a lot of stuff ongoing about AI and like reusing things. And I saw one recently. They'd created this really, I mean, it was an amazing image of really complicated, really useful that this group had actually used in quite a lot of their materials. It was based on, they'd consulted with some members of the public and they'd used it to create this picture. But we don't really know. There is no way of knowing where the stuff comes from. So from the, like now in Google, you get the AI summary before you actually get the normal sort of search terms. And obviously the other search engines do exist, and there are other AI platforms, and they do sometimes give you links so that you can see where the information has come from, and then you can actually make a judgment call. With things like images, you have no idea. So I'm a bit nervous about it as an IP professional, and I certainly wouldn't want to like registering anything or use anything in any materials that were going out very broadly in case there was, I mean, I'm going to make up an example. I don't know if this is true, but let's say you wanted something really unusual, so something that nobody had really thought of before. So there weren't many images that had that sort of thing in it, and therefore it then used that. I don't really know where you'd stand, and also you wouldn't be able to prove that you hadn't copied.
I just wondered if there was
difficult.
like a like say ChatGPT, whether they have something in their legislation about using an image. Do you have to get authorization from them to get the? Do you know what I mean?
Yeah.
Is it
So
like
there's
a trail?
yeah.
Trail?
There's a lot of stuff going on at the moment in sort of governments and so on, and the law looking at, do they need permission from other people to use other people's stuff? So authors, songwriters, they're all concerned about their things being used by AI, obviously artists and things like that as well. I don't know about ChatGPT. I know there's lots of discussion about it and lots of I think governments are trying to balance the benefits that AI could give versus the risks to the copyright owners and to jeopardizing their livelihoods. We're getting a film created, and the company we were talking to was saying, oh, well, we won't use a voiceover. We'll just use an AI voice, AI generated voice, and you can say it a bit more softly, be a bit more positive, and it's really quick. We don't have to get them to re-record it. We can get them just to change one section. So I guess what I'm saying is we don't have all the answers yet.
Fair enough.
But do be careful, and also be careful when you're putting stuff in, depending on which system it is. And again, I don't know all the details. It can sometimes reuse things, when other people are asking questions. So I would be careful about, if you were, say, writing, I don't know, perhaps a paper and wanted to improve stuff, I would be very careful checking that it isn't going to reuse what you're putting in there.
Sure.
Before you use AI to help you, or anonymize all the key bits so that it's just helping you with the sort of the bland wording at the front and not your core results. I don't have all the answers, but I am nervous about, not about, I think AI has a place, but just about some of the IP issues.
No, thanks for that.
Good question. We're 1 minute over. I'm sure everybody has a very busy diary, so we'll bring it to a close. And thanks so much for staying and listening and engaging. I will be sending Claire the recording and the presentation afterwards to share with other people. And just, thanks for your time.
Thanks very much.
Thanks so much, Jo.
Bye.
See you.
Thank you.